This afternoon, we are here for the 2020 Alice Cook Lois Gray Distinguished Lecture. I'm Alex Colvin, Dean of the ILR School, and I'm pleased to welcome you to what's one of the highlights of our intellectual life every year at this school. This is a lecture that honors two of our most distinguished, long-serving faculty members who were real pioneers in founding the school and making what it became. This is our 75th year as a school, and this is a wonderful opportunity to celebrate their accomplishments through this distinguished lecture. It's a real pleasure to be having everybody joining us today, even though this is a virtual lecture due to the COVID-19 pandemic, and so we're not able to be here in person through the magic of Zoom and the very hard work of our tech support staff. I want to shout out to DH Goodall and our tech support team who do an amazing job in making events like this happen. We can all be together and be here to hear our very distinguished lecturer today, Adelle Blackett, an internationally renowned scholar of international labor law, and also one of my fellow country people from Canada. So it's a real pleasure to have her here joining us today. I do want to start out by acknowledging our two organizers of today's lecture, Rosemary Batt, the Alice H. Cook Professor of Women and Work, and Pamela Tolbert, the Lois S. Gray Professor of Industrial and Labor Relations and the Social Sciences, two of our distinguished faculty here at the ILR School who both hold chairs that honor those distinguished early faculty members at the school, Alice Cook and Lois Gray. So I want to thank them for organizing today's lecture, and then I'm going to pass over to Professor Batt to introduce today's lecture.
Great. Thank you so much, Alex. Thank you for your remarks and for your support of this really important annual lecture. And I want to welcome all of you to this event. We have over 100 people who have signed up and are participating on this beautiful fall afternoon when the colors in Ithaca are still in full bloom. So I thank you for joining us. And as Alex said, I'm Rose Bott. I'm the Alice Cook Professor of Women and Work. And I'm very pleased to welcome you and honor Alice Cook and Lois Gray, who were distinguished faculty and among the first women hired at the ILR School. So I also want to acknowledge several people. Dean Colvin mentioned the tech staff, also Jen Morley, Pam Staub, Mary Catt, and Don Baisley, and all of the communications and IT staff who've been fabulous. And then finally, the co-sponsors of this event, the Center for the Study of Inequality and the Feminist Gender and Sexuality Program at Cornell. So before I turn to Adelle Blackett, I want to first give you a bit of background about how this lecture series has evolved. It began in 2004 in order to honor the legacy of ILR founding women who dedicated their lives to promoting equality and social and economic justice, both through their academic research and through their advocacy and activism. So they were true scholar activists applying their research to solve really real world problems. Turning to Alice Cook, she died in 1999 after some 50 years of being affiliated with the ILR School, and just after completing her autobiography, which was called A Lifetime of Labor. And it captures the essence of her life as a scholar activist for nearly 100 years in the 20th century. So just a few examples. When she was 13 in 1919, she marched with her mother in front of the White House for the women's right to vote. Then in the 20s, she went to Germany to study the worker, labor, and education movement and brought those ideas back to use them in the labor movement in the US in the 30s. Then after World War II, she went back to Germany to help rebuild the labor movement. And in 1952, she joined the ILR School and continued then to work with labor unions and working people throughout the state of New York and beyond. At Cornell, she also did the fight to integrate the faculty club at Statler because women were not allowed until about the 60s. And she helped when the campus protests in the 60s and 70s were in full swing, the university asked her to be the ombudsperson to bring together the students and the faculty. She was an amazing woman. And now turning to Lois Gray, she was a founding member of the ILR school in 1947, the first woman hired when she was 22. When she died in 2018 at 95, she was still going to the office almost every day. And that was after 72 years of working for the ILR school. She was a leader in building our outreach and supporting working people throughout the state of New York and beyond. She became the associate dean of the ILR school, and under her leadership, built out many innovative programs such as the Institute for Women in Work, the Latino Leadership Center, international worker exchanges, and off-campus credit so that working people and union leaders could get further education. Finally, she had a PhD in economics, and her publications focused on labor market issues for women and minorities, and she was well acclaimed. So now let me turn to Adelle Blackett, who exemplifies this kind of lifetime commitment to scholar activism, like Lois and Alice. Adelle Blackett is the professor of law and Canada Research Chair in transnational labor law at McGill. She holds a BA in history from Queen's and a PhD in law from Columbia University. She is a prolific scholar in the fields of labor and employment law, trade regulation, critical race theory, and slavery and the law. Her many books, edited volumes, and articles have been widely published in French, English, and Spanish throughout the world. And she has received countless awards, and I won't begin, but here are a few: the Queen Elizabeth II, the Second Diamond Jubilee Medal, the Christine Torinde Award of Merit in recognition of her social commitment and her contributions to the advancement of women, a fellowship for the Pierre Trudeau Foundation, a member of the International Academy of Comparative Law, and a fellow at the Royal Society of Canada, to name a few. Importantly, she has applied her scholarship to solving real world problems. And this is in examples like being a consultant for the corporate social responsibility issues for the Lawyers Committee for Human Rights, and as an official in the International Labor Office in Geneva, where she led the adoption of the International Standard for Decent Work for domestic workers. So she is a brilliant career, and we're so proud to have her here to speak to us today about her work. And so I now turn it over to Adelle Blackett. And please note that we will allow her to speak and kind of do her presentation, then bring down her slides so that we can have Q&A. And you're welcome to put questions in the Q&A box at any time, and we will gather them and have a fabulous discussion at the end. So with that, I want to turn it over to Adele. Thank you so much for being here.
Thank you so much. Thank you, Dean Colvin. Thank you, Professors Batt and Tolberg, for the invitation. I'd also like to thank the technological staff and all of the people who made this possible. And Professor Batt, thank you for such a warm welcome to Cornell's ILR School on the occasion of the Alice Cook Lois Gray Distinguished Lecture. I'm absolutely delighted to be able to address you, even if virtually, on this wonderful fall day in Montreal as well. And I wish to acknowledge that both of our universities are on traditional unceded lands of the Haudenosaunee Confederacy. I'm humbled to be able to give a lecture honoring the trailblazing scholarly labor and social activist work of Alice Cook and Lois Gray. I've come to understand, aided in part by the copy of Alice Cook's autobiography that Rose very kindly offered me, the deep way in which throughout their lives they understood social justice movements to be interconnected. And I'm moved whenever I learn, in addition, as Alice Cook's publisher said, that someone's scholarship and political commitments were not left in her briefcase or on the streets where she marched, but were carried home and reflected in the way a colleague and comrade understood and structured her own childcare, and in the way in which she understood and cared for her colleagues and others. The way, in other words, she embodied social justice. I've spent much of my life work on the International Labor Organization because that century-old organization has also sought to center, dare I say embody, a fulsome vision of social justice, one that could hardly be more relevant in this pandemic, a moment that's exposed deep, long-standing, and multifaceted injustice, from anti-Black racism to record economic inequality, and the urgency to unsettle it. As the people who care for others, domestic workers are accustomed to not being really seen, not being really heard. Historical accounts remind us of the link to domestic slavery and colonial servitude, and of the persisting vestiges found in the common sense of the status-based relationship of the master and the servant. The many poignant sociological accounts of domestic work in post-colonial settings or post-apartheid states emphasize domestic workers' invisibility, even as they perform the hard and dirty work associated with social reproduction. The political economy literature stresses the extent to which domestic workers, often highly educated and with care responsibilities of their own, leave families and home to travel abroad to provide care. All capture the extent to which this traditionally feminized work remains economically and socially undervalued. But none captures it better than domestic workers in their own words. Fatma El Ayoubi wrote Prière à la Lune, Prayer to the Moon, a book that this domestic worker of Moroccan heritage living in Paris wrote while recovering from a nervous breakdown. She consciously chose to speak for all the Fatimas who work in the shadows alone, far from their families. El Ayoubi reminds us of the art that inhabits her backbreaking work. And I quote, "Many people do not understand what is art. I've always worked looking for the elegance in what I do. Even when I iron a shirt, I want to feel inside of me an aesthetic harmony. I iron shirts I dust. I clean the world to admire the beauty and the cleanliness, this art to which I have applied myself 9 hours a day, each day, all these years. No one sees it. When I come back the next day, I commence to suffer yet again in my body and in my soul. I am a woman who uses her body as her work tool. Nothing else is left." The book I wrote is about how domestic workers launched a transnational movement, framed through human rights, that was not only about their inclusion in the corpus of labor law, but about how they helped to transform the understanding of their work, and through it, the understanding of our fields. To transform that understanding of their work, they needed to break through the invisibility that Fatma El Ayoubi so poignantly characterizes, the historically racialized relationship that can be understood as deeply unequal, informal, but widely understood as a form of law. In the book, I argue that they transgressed that asymmetrical law of the household workforce. In this presentation, I will underscore how domestic workers did this. And by domestic workers, I'm relying on a rather broad definition that was actually adopted in the international treaty that was negotiated and that we now refer to colloquially as Convention number 189. The term domestic work means work performed in or for a household or households. So about as broad as it could get. The narrowing happens in the language of domestic worker or any person engaged in domestic work within an employment relationship. And it's the interpretation, of course, of the latter employment relationship, a term that is defined broadly by the ILO in its relevant recommendation, but that narrows the scope. But a lot has happened in the 9 years since Convention 189 was adopted. and it is impossible not to consider the weight of the present moment. According to the ILO, the livelihood of 55 million domestic workers, that's 3/4 of the 67.1 million domestic workers worldwide, 80% of whom are women, 11.5 million of whom are migrants. It's that 55 million domestic workers who are at significant risk due to lockdown, due to COVID. And this largely is linked to the lack of effective social protection. They've lost their jobs. They have no source of income. Consider, for example, the network of former Ethiopian domestic workers currently living in Montreal, Enya Lenya Besidet, meaning from us migrants to us migrants. Its members are literally paying for domestic workers' repatriation as domestic workers from Ethiopia, Kenya, and Nigeria, alongside domestic workers from the Philippines, Sri Lanka, and Bangladesh, literally camp outside their respective embassies when their employers ended their employment contracts in the mix of the COVID-19 crisis, socioeconomic downturn, and in the specific Lebanese context, the tragic explosions. When everyone else is suffering, dare I say, domestic workers suffer more. Their needs remain invisible. Some other domestic workers find themselves confined in their employer's household as the families of domestic workers who employed them prioritize their own safety, and as public health rules overlook or ignore the specific safety concerns of domestic workers. The label of essential workers, as frankly we're seeing in the AFL-CIO's recent complaint to the ILO's Committee on Freedom of Association, it underscores the label is too often not deployed to protect the workers themselves, but rather to compel continued work for others. So who cares for domestic workers? It's not as if the ILO had never turned its attention to domestic workers before the standard setting in 2010, 2011. The subject of establishing international standards in the form of a treaty that could be ratified by individual member states and non-binding recommendations on domestic work had come up repeatedly at the ILO. 1936, 1945, 1948, 1965, moments when the ILO adopted resolutions to do something. They even called it urgent, compatible with the self-respect and human dignity essential to social justice. Now consider this. 1 in every 25 women working in the world is a domestic worker. Yet since 1919, the ILO has repeatedly set so many standards on another category of migrant workers, seafarers, who are also facing a terrible situation in the middle of the pandemic. But they established through the ILO a global consolidated standard with significant industry support by both employers and workers, and the support of the International Maritime Organization in 2006. They also bargain collectively transnationally. There are 1 million maritime workers in the world, 67 million domestic workers. A standard on domestic workers and the abuse that they face in an era of mass female migration seems therefore altogether overdue. And according to the ILO, 8% of all migrant workers worldwide are migrant domestic workers. 8.45 of the 11.5 million migrant domestic workers are women. but few underestimated the challenge internationally. Labor standard setting had generally ground to a halt when the ILO picked up the issue of domestic work again in 2008. The ILO had faced a colossal challenge in its attempt to regulate contract labor. The setting of a minimum wage was under challenge. Termination of employment standards were being challenged. Freedom of association standards, and in particular the right to strike, was being challenged. There was real concern that standard setting would not be possible or would lead to a whittling away of core aspects. So while I was drawn into the law reform initiative transnationally, I got involved with a strong sense of purpose and a strong sense of how this work connected to that broader challenge to standard setting, but also connected to a longer history that is community-based and that is global. It's wed to the Black diasporas worldwide, and including in Canada, where, thanks to a 1955 Memorandum of Understanding between Canada, Jamaica, and Barbados, a path to immigration was opened up for racialized migrants. The women from the Caribbean who obtained permanent resident status as soon as they arrived, because the memorandum stated that to give them anything less would be akin to forced labor. How times have changed. And these women also, of course, obtained the status in that period, early 1960s, on the basis that there were assumptions that these women wouldn't want or be able to do anything else than become domestics. They weren't anticipating the Honorable Jean Augustine, who became the first Black member of federal cabinet in Canada, who came from Grenada on that scheme. And they weren't anticipating women like my own mother, who left domestic work once her 2-year responsibility was over and found work in unionized jobs and worked hard to pursue their dream of better future for their communities and their own children. So back to the ILO, I contend that domestic workers' quest for transformative inclusion through this standard setting that many were concerned about actually helped to change the ILO itself. It helped to make it remember the power of rooting legal change, international standard setting, in the urgent claims of social movements. Bottom-up process. Domestic workers showed with certainty that this was the right direction for the ILO to take. And in the process, showed the ILO the potential of its own transnational future. Having grown up knowing the power and militancy of women in my communities, I was struck at the start of the standard setting process to be confronted by an additional challenge. People questioning whether domestic workers actually had a working class sensibility. This is a framing that speaks volumes about the origin stories that we've given to labor studies generally, and labor law in particular, situating it in a vision of the industrial revolution that leaves out broader stories about resistance, including stories that take us to the relationship of current economic relations to slavery and movements for emancipation. There's a more contemporary related history that also seemed to have been missed. How many people, when they think of the Montgomery bus boycotts at the height of the US civil rights movement, think of the massive number of domestic workers who insisted on walking to work. Almost 65 years ago, Rosa Parks, a longtime activist, refused to give up her seat and the boycotts began. But domestic workers were not just following orders. As historian Premila Nadesan compellingly conveys, they acted at great cost and risk, insisting on respect for their civil rights. Domestic workers' massive participation in the civil rights movement has deep links to movements for their rights as domestic workers. Indeed, as Nadesan argues, the struggle for domestic workers' rights brings greater nuance to the meaning of Black freedom and labor organizing. And in another example that is strikingly consistent across the world, domestic workers have tended to reject live-in and opt to live out whenever they've been able to do so. These forms of resistance have been crucial to enabling domestic workers to carve out some limited autonomy in their highly personalized work relationships. Domestic workers have also acted collectively in senses that we more likely recognize in labor studies, including through media campaigns, lobbying efforts, hunger strikes, and call for one-day work stoppages. So a decade ago, domestic workers, that category that scholars and activists have repeatedly considered not to have a working class consciousness, formed a transnational network that is now a transnational union federation, and they militated for an international labor standard at the ILO that would force structural change to the uneven law of the household workplace and help to sustain a global consciousness about the dignity of the work they do. Next slide, please. The negotiations on the standard setting on domestic work took place, as I mentioned before, in 2010 and 2011 in a Geneva committee room in the United Nations Palais. In the book, I chronicle the process not only of getting the standard setting onto the ILO's agenda, but also the deliberative process that led a certain number of common sense understandings of the regulation of domestic work to be unsettled. But I won't focus on that process today. I will, however, point out the deeply exclusionary character of what makes the ILO such a unique, but also in some ways challenged organization. It's tripartism, through which it makes space not only for governments, but also for workers and employers' representatives. The importance of this structure, but also some of its limits, became palpable in relation to domestic workers. Some could not help but point out that there were employers of domestic workers in all three of the ILO's typical tripartite categories: employers, workers, and governments, as well as in the ILO's secretariat. For the most part, domestic workers themselves sat as observers, literally outside of the circle of delegates, although the workers' group in particular employed Herculean efforts to ensure that workers would be as much as possible included, domestic workers would be as much as possible included within the ranks of the workers represented. And the domestic workers, wherever they were, used their limited time that the committees got together and agreed to grant them at the beginning of each year's session extremely well. They conveyed their strong convictions about the necessary content of the convention and recommendation. And throughout, they forced constituents never to lose sight of the seriousness of their decent work claim. Next slide, please. Domestic workers help to build a new transnational legal order to dislodge the asymmetry in their work relationship. That claim is far-reaching. The common sense about how the domestic work relationship is understood, regulated, and learned is part of a global legacy of subordination and servitude. It operates in particular places, in particular ways, on particular women's bodies. I refer to this as the asymmetrical or uneven and largely invisible law of the household workplace. And frankly, I found an interesting example of this in Alice Cook's memoirs when she referenced her experience that she remembered going back in some of the homes she visited and seeing, at the time, KKK signs in those houses, and recalling that for those people, the law for them was that organization. And the language of law, the capacity to see, to acknowledge invisibility in law, to know that nothing about the relationship is made to allow you to actually see the inequality because it's normalized. We're not meant to take it, we are meant rather to take it as a given that we're not supposed to see domestic workers' social location. We're not supposed to see, for example, in a place like Brazil, that the overwhelming majority of domestic workers happen to be Afro-Brazilian. And this is not a historical accident. We are not supposed to see the workers' needs, desires, aspirations. The relationship involves the domestic workers, but the condition is that they get everything done, the cooking, the cleaning, the other menial work, which includes much of the childcare and even the emotional labor, so that it seems invisible. The law of the household workplace does not require the state to enact legislation. It does not require a court to decide a case. In this sense, the definition is sociolegal. It recognizes that the domestic work relationship over time, in particular places, has generated its own well understood law. So when regulating decent work for domestic workers, it's simply not enough to accept that naturalized, uneven law as it is. It's necessary to make it visible, to dislodge it, for a transgressive alternative order to emerge. In this sense, the framing in the standard setting really mattered. It turned out to be helpful to understand domestic workers' access to labor rights as human rights concerns. Domestic workers could be seen to be excluded from labor law. They were thought of as somehow regulated under family law, just like one of the family. There was a shift in frame. This is actually about labor law. Why does it look so different when we treat it as labor law? It led to some really interesting moments in the committee rooms. I refer to them in the books as aha moments for delegates in the International Labor Conference's discussions, where it became clear that domestic workers should even have something like a minimum wage, and why it was crucial that workers be remunerated for the time they were working, not like one of the family, actually workers like other workers. Domestic workers' inclusion in a labor law framework started to become obvious. The extent of their exclusion started to be understood, seen. The need for action seemed urgent. Next slide, please. To begin to understand this, to begin to make these differences visible, is, of course, to transgress that asymmetrical law of the household workplace. Domestic workers, of course, transgressed regularly, on a daily basis, the house and the market, the national, the transnational. But the claim I'm making is more than that. They embody a long historical tradition of resistance, where they've refused to confuse the laws that exact servitude with social justice. So the standard setting on decent work for domestic workers was a big part of how to work against invisibility and to allow what domestic workers understood and were seeing to become centered. The proposed convention and recommendation were therefore a tall order. These were not light, slender charters even, and they could have scared away the faint of heart. The claim at its heart was simple. It resonated with domestic workers' social movement claims, and it resonated with those who took the time to understand why the work was so important. Groups like the National Domestic Workers Alliance lost no opportunity to underscore the fundamental humanity of care work, as well as its economic importance in the home, the central dignity and humanity of caring for others. Domestic workers had a substantive equality right to be meaningfully included in labor law. I wanted the ILO's standard setting process in particular to be part of rethinking labor law's boundaries. The biggest challenge was to ensure that domestic workers had the right to be included in labor law, and that meant all of labor law, despite the challenges that were underway on standard setting as a whole. This was significant. They were detailed and comprehensive. They were meant to give a broad meaning to the notion of decent work that the ILO had been championing since 1999. Decent work would come to mean decent working conditions, but so much more. It would mean recognizing domestic workers' equality rights, recognizing their freedom of association and doing that in very concrete ways, providing protection against forced labor and child labor. It would come to include access to social protection that includes maternity leave, occupational safety and health, and social security protections, even though in some of those there is an attention to progressive realization of those rights. But there was even more. A premium was placed on making sure that mechanisms for inspection and for dispute resolution were actively available to domestic workers. So decent work would also mean that special attention was needed around the fault lines of migration to rein in exploitative practices. Next slide, please. One of the key areas of some movement in the migration front was on the live-in requirement that is so prevalent in many of the migration schemes. It put a number of countries, including my own, in a somewhat challenging position. In the 2010 session, the Government of Canada sought to introduce an amendment that would add the words, unless residence in the home is a condition of employment. And the justification was that residing in the household could be a condition of employment, for example, in the case of taking care of children, persons with disabilities, or elderly persons. The proposal was immediately supported by the employer's vice chairperson, who added further text. And the amendments were equally swiftly opposed by the workers' vice chairperson on the principle that the freedom of the parties to negotiate was being taken away. A lengthy discussion ensued on the matter, framed around the freedom to negotiate a contract. The unmistakable subtext, of course, was that the plethora of migration schemes, including Canada's, that were built around the requirement that domestic workers live in, is intimately linked to the logic of sponsorship by the employer, in some regions referred to as the kafala system, although the system does not require migrants to live in for all occupational categories, for example, in countries that include people like judges under the kafala system. But for domestic workers, the link has tended to be made, and the assumption has been that it is naturally related to the fee paid for the employer and to the kind of work expected of the domestic worker. And it has enabled untold abuse. Anyhow, the conference committee was not having it. The provision of the draft convention stood, and Canada has since removed its live-in requirement from the caregiver's scheme. And so some movement has occurred in relationship to this, even though there are moving targets in relation to that, and in particular, the ways that one communicates to domestic workers that based on scarcity, they might move in. Next slide, please. So my work on domestic workers was meant to thicken the understanding of how transnational legal orders, like the one surrounding Convention number 189, were built, and how they challenge uneven relationships before they can even aspire to settle and diffuse alternatives. And frankly, although some of this work is built on some of the scholarship on transnational law and on the need to acknowledge and dislodge uneven power, some of the sources for doing this were entirely unexpected, and frankly, were the source of great joy. One of the sources, historical sources, that I won't deny that I delighted in finding was cookbooks. Cookbooks from different parts of the world, from colonial contexts, from the United Kingdom, from the postbellum and antebellum US South. In some cases, these cookbooks were amongst the first books ever written by African American women and men, like Mrs. Melinda Russell's cookbook, which is referred to by Tony Tipton Martin as the author's Emancipation Proclamation. And these sources included not only remarkable recipes, which I read, but they included characterizations of the relationships, chronicles of how some domestic workers or some cooks changed the relationships, and provided a really powerful site through which to understand the law of the household workplace and to see how actors were thinking through moving beyond. Next slide, please. One of the most compelling transgressions of the entire process is that the comparative law learning that was so central to developing and then sustaining Convention 189 was that the learning did not necessarily radiate out from the global north to the global south, but rather emerged from those distinct places where it has just been necessary to grapple with the relationship between servitude and subordination to reimagine domestic work as decent work. South Africa stands out as an extremely important example of this. South Africa played a pivotal role in establishing Convention number 189 before, during, and frankly, since its adoption. In 1991, the government of South Africa, newly emerging from a system of legal apartheid, recognized that it needed to respond to a particularly potent symbol of apartheid: Black women relegated to care for whites in gated communities while their own children floundered in townships. The new African National Congress-led government could not promise these workers that they would all just immediately leave domestic work, but it needed to address the challenge of regulating the employment relationship as decent work, respecting the worker's dignity. South Africa agreed to an official ILO fact-finding mission on its working conditions generally. It called domestic workers' exclusion from labor law one of the most serious problems affecting the freedom of association in the country. It sought guidance to reform its labor laws from the ILO, and on domestic work, South Africa adopted a sectoral determination, a form of specific regulation of domestic workers' rights with a focus on how minimum wages were set and calculated through the basic conditions of employment legislation in 2002. It also included regulations on key aspects of the employment relationship, but most interestingly, I think, it's that domestic workers were included in the new and original Commission for Conciliation, Mediation, and Arbitration, or CCMA, which offered a wide range of low-wage workers access to mechanisms to recognize their rights. In 2014, I had the opportunity to observe some of the CCMA process in action, and I watched domestic workers and their former employers face one another across a table over termination and employment cases. In one case, the domestic worker was a single mother. She lived in precarious housing. She had trouble getting to work on time, and it seemed barely to be able to meet her employer's eyes. But she sat next to an interpreter appointed by the CCMA. She was able to address her employer in her own language, and she was able to express her claim in her own words and in a manner in which the commissioner who was there could really listen to her. For sure, this termination case was not hard to see, and it was not hard to see either that this case would be settled. A woman with no job, children to feed, house that floods, but she was heard in this context. And within less than a few weeks, in a context characterized by respect for her. There was, of course, a risk of rapid justice, but the interviewees from domestic workers associations reminded me that although imperfect, the mechanisms were important ways to diffuse the understanding that domestic work is decent work, that employers were no longer meting out their own law, but were actually understanding the relationship as one subject to labor law. So South African innovation has been significant. It was critical to the preparation of Convention 189 to the Law and Practice Report. It was critical to discussion. South Africa was deeply proactive in the negotiations. And it was critical that South Africa became one of the first of the currently 30 countries to have ratified Convention number 189. Yet some of the most trenchant critiques also come from South Africa. And I'm going to end with them. For one, the historical self-consciousness of the regulation of domestic work in South Africa can hardly be forgotten. There has been change. And now, although employers span the racial categories in South Africa, and although domestic workers mostly live out, virtually all domestic workers remain Black. Domestic work is still performed by the temporally oppressed but spatially dispossessed subaltern in post-apartheid South Africa. Migrant domestic workers in South Africa from neighboring countries pose significant challenges to regulation, and one that keeps racialization at the forefront. In addition, scholars and activists from South Africa have wondered whether domestic workers' historical exclusion from labor regulation that is being addressed is now something that is, frankly, just part of a more generalized neoliberal unraveling of employment law that leaves domestic workers in many categories without social protection, vulnerable to risk, including the risks associated with COVID-19, and at the mercy of the market. Domestic workers, in other words, are part of a continuum on which increasingly typical but precarious or contingent work is located. The pandemic, in particular, has made that sometimes abstract feeling critique quite intimately understood. What happens to those workers who overnight have no more job, or who are trapped in their job, literally in some parts of the world, trapped in the households where they are not allowed to leave and exposed? Next slide, please. I conclude the book by making the beginnings of the case for transgressing Convention number 189's own borders. That is, for rethinking what multilateralism must look like. Yes, Convention 189 was adopted on June 16th, 2011. Yes, there was singing and dancing on the committee floors, and rightly so. Yes, to date, 30 countries have ratified the convention, which makes this one of the better ratified international labor conventions, particularly since so many receiving states, including of migrant domestic workers, have signed. As I argue in my book, however, a significant dimension of this international standard setting is that while ratification is important, much change can and must happen beyond ratification, because what it has been created is a transnational community of learning on decent work for domestic workers that is committed to making domestic work visible and changing its foundation. So with COVID-19 and its unparalleled window into the nature of the injustice faced by domestic workers understood to be essential, I believe we must begin to address the issue of global social protection. That is, how can we put in place multilateral mechanisms that ensure certainly that workers are not alone to shoulder risk, and ultimately that economies that are poorly placed to shoulder the burden alone are able to engage in thinking through the redistributions that are possible. I note that the International Trade Union Confederation is calling for a form of global social protection. And this is a strong reminder of what domestic workers have been telling us throughout the standard setting. Social justice requires us to think transnationally. So let me close. Next slide, please. So let me close with a quote from someone and inspired me, Myrtle Witbooi, celebrated domestic worker and anti-apartheid activist from South Africa, the president of the International Domestic Workers Federation and the force behind much of the movement. She addressed the International Labor Conference in the first of its 2 years, so in 2010, and she had this to say: We've managed to bring domestic workers to the ILO, and I'm sure you will feel the spirit and see the hope and expression on our face. We want to show you the importance of domestic workers who contribute to building the economies of the world by looking after your families and your homes. We are sure that for the first time, the delegates at this conference would feel, hear, and experience the unity amongst the domestic workers. And maybe we'll convince you that united, we can move mountains. Thank you.
Adele, thank you so much. That was beautiful and inspiring. And we already have a couple of questions that I hope you will respond to while we gather more. So the first is a fairly specific question, which asks, do you think the CCMA proceedings are a viable substitute in granting access to justice for domestic workers compared to traditional courts and litigation?
Oh, great question. Thank you very much for that. I was actually really struck, excuse me, I was struck by the extent of the access to justice provided by the specialized mechanisms. The mechanisms don't replace access to arbitration. They introduce mediation-based and conciliation-based processes ahead of time. And what they offer, and frankly, what I think many labor mechanisms aspire to offer but are unable to offer, is swift proceedings, right? So we're really talking about domestic workers who are able to walk into the CCMA buildings on Monday and know by Friday when they will have a hearing and come back the next week and have a matter potentially resolved within an hour on the substance. And other mechanisms then are put in place with the ability to move into conciliation and arbitration, as well as mechanisms that are of a more traditional nature when a matter might actually need to go to labor court. So they're part of a panoply of measures, but what it meant was that domestic workers were going to labor institutions to seek a resolution of their matter. Whereas we know in so many jurisdictions worldwide that domestic workers have no realistic option of the sort. The common feature, frankly, in these mechanisms, alongside many of the ones that we see in other jurisdictions, including my own, is that they tend to be used on termination, right? So they're not providing resolutions for the most part during the life of the employment relationship.
Great, thank you for that. The next question is kind of two-part, so I'm going to give you the first and then the second. The comment is that, well, first, thank you for an incredible, moving analysis of social movement demands for legal recognition of domestic workers. In addition to the factors you described, maintaining the deeply entrenched inequalities of domestic workers' labor conditions, would you please comment on the following factors? So the first one is the romanticized vision of small business and family business as appropriately outside the realm of government regulation of the employment relationship.
Yes, really perceptive, and it does feed in. And we see this a great deal in the way in which farm labor, agricultural labor, tends to be conceptualized, right? Imagined as family farms, small business, and then left on its own. This has historical roots, right? In the understandings of a household economy. And we're moved out into a different narrative, a narrative that took us straight to industrialization and the factory as the prototype, and then offices and like, but not to reckoning with what it looks like to work in small entities that have what may be framed as a family component to them. We've left that as, well, to repeat myself, its own law, right? The law of another. And so we find ourselves falling into the metaphors of the family and a different source of autonomy. Interestingly, of course, we've broken out of that in much of the family law work, right? So the analysis, of course, through feminist mobilizing, challenged that boundary and created spaces for regulating to promote equality. Ironically, in labor, we've left areas like domestic work, framed them as pre-industrial, and left them alone, and not quite grappled with or built as the same kinds of alternative frameworks for understanding the regulation. Now, a slight caution, I don't either want to subsume agricultural labor, domestic labor, into the theorizing around in industrial relations around small businesses. I think there's the nexus that I've captured, but there are distinct features happening in relation to them as well that I think we need to at least acknowledge. But I think you put your finger on the common reluctance to have state regulating in relation to them, or the same kind of state regulating. And part of what this work encourages us to do is not to allow the specificity of work sites to be met simply with a response that is, so we don't go there, right? We don't question that authority. On the contrary, we need to understand it deeply, identify the bases of the inequality, and think carefully about how to regulate to ensure that you are working in a labor relationship that is understood as decent work.
Terrific. Let me give you the second part of the question, which is another factor that is contributing to maintaining these inequalities: the contradictions in fiction of the public-private distinction, the denial that government refusal to regulate is a form of government action, that is subsidizing household employers.
Yeah, very, very good. And I think I touched a little bit on that, the breakdown in the dichotomy, right? So the need to name it, challenge it, and then direct it. There's a different dimension which you might be hinting at as well. So beyond the dichotomization between public, private, as the household is private, the government action is public, different spheres, and it is more of a regulatory question, but it is the regulatory question, frankly, for employment law. We know that the way that we have conceptualized contract law, right, the private bargain, the relationship between, of course, the assumption is equals, and although employment contracts allow us to be explicit about the inequality of bargaining power, the contractual frame leads us to obscure the centrality of status, right, in the relationship. And frankly, the really important dimension of working through the historical material, in particular on domestic workers and the master-servant relationship, very literally, right, is that status is so central to the understanding of all of the duties that then follow, right? And the starting assumption is the asymmetry. Right? And so working through that, right, allows one to ground again in what actually has not changed in the passage, so to speak, from status to contract, right? And if you can make that status dimension explicit, then you also make the basis for regulatory action clearer, right? And certainly more compelling. It's not lost on those who turn back to Blackstone that the core relationships were relationships of inequality, right? And that included, of course, marriage, as well as the master-servant relationship. So doing this historical work becomes really important for challenging then the reluctance to engage in the kind of work that needs to happen if you're going to change the character of an employment relationship and not just assume the inequality and ignore it.
Great. We have a number of questions, so I'm going to try to move you through them. We have about a little less than a half hour. So the next question is about how the ILO has responded to challenges that COVID-19 has posed for domestic workers, and how have domestic workers organizing responded? In other words, if you can elaborate a little bit more on that dynamic that's going on right now.
Yeah, super important. So the ILO has centered this issue. There are certainly comments about the kinds of circumstances. Collecting some of the information has been an important part of what the ILO is doing publicly. Its standard setting role continues as well, or standard monitoring role through the Committee of Experts, which surveys the responses. What I would like to see more about from the ILO, and of course I'm not at the ILO myself, is the kind of support they're providing directly to governments that want to regulate, turning the minds of legislators to how to put in place guidelines or regulations or other measures that speak to the experience of domestic workers and how to keep domestic workers safe, how to ensure social protection, how to ensure continuity. What we're seeing in some of the comparative law material, and some of my colleagues have recently written a very nice piece about attempts by domestic workers themselves, and sometimes aided through legislation, to organize. So the Danish example of collective bargaining through platforms, which provides employment protections and the like, and then the battle in the courts, right, where the courts are thinking about this kind of thing through competition law, rather than as enabling collective bargaining of groups of workers who most assuredly are not in an anti-competitive position, right? They're very clearly trying to overcome existing hurdles to be able to take their own conditions into hand. And so there are areas like that where guidance from the ILO would be extraordinarily helpful in setting directions for law reform. There's already, of course, interpretive guidance through the ILO's Committee of Experts work, but there's a lot. And domestic workers themselves, I mean, there have been many campaigns, including campaigns calling for support from broader communities so that domestic workers organizations can themselves build social protection for their members. Obviously, these are limited mechanisms, right? There's a need for regulatory change. There's been a lot of lobbying. Of course, National Domestic Workers Alliance has been so strong on this and has also faced recent setbacks in jurisdictions where it looked like legislation might go forward. But domestic workers are extremely active in many parts of the world on trying to find support. But it's a really it's an extraordinarily challenging time for domestic workers who are literally just seeking survival.
Thank you. So thank you. The next participant says, thank you for an amazing talk. Can you say a little more about the parallel efforts for global social protection for workers, but also for migrants and women? How do these frames differ or align? And how are these distinct or overlapping efforts working together?
Thanks very much for that question. Really apposite. And there are different ways of going about this. And I'm not in any way, shape, or form suggesting they've gained a ton of traction. I think we're in early days for movements for global social protection. And whereas we might have been feeling that there was a real opening toward the beginning of the pandemic, there's a hard reality that's for many of us settled in to the almost, continue as usual. Essential workers, okay, we've called you essential, keep working, but we're not actually going to change your circumstance, right? This is a moment in which multilateralism is deeply called into question. Many of the institutions are not functioning well. There are approaches that seem to be encouraging states to spend on social protection, encouraging more borrowing for that, loosening of conditions, some attention to debt waivers, but not as much attention to how we can create structures of support that are transnational, that involve multiple states, that involve north-south arrangements, or that are institutionalized within individual spaces. So the strongest voice to date on global social protection remains, to my mind, the ITUC, International Trade Union Federation, and the various initiatives that are being taken in individual states to change legislation, to consider universal basic income schemes of a temporary or broader nature. These are not the same, but related, and move towards, how you enable people to be able to shoulder the crisis without bearing all of the risk on their own shoulders. So those mechanisms are in play, and they're not coordinated across borders in the way that an attention to global social protection would allow them to be. So we're early days, and it's a time, I think, for really careful but creative thinking, right? The last thing I'll say, I know there are a number of questions, but I was struck this summer when the UN Secretary General spoke on a few occasions about the importance of building a global New Deal, and very specifically addressed different forms of inequality, naming the pandemic, naming income inequality of record proportions, naming racial injustice, naming the climate crisis. And, where these moments of recognition take us, right? So much depends on, of course, the ways in which, frankly, social movements take these initiatives and run with them, hold institutions accountable for them. And I would find it unfortunate if we were to lose that moment of clear-sightedness and real vision and revert to, some version of business as usual in the so-called new normal. We shouldn't be accepting. that kind of new normal. This is a moment for much deeper, much richer thinking about where we want to be in our societies.
So that brings us to the US with a question. Since the current president of the US does not recognize most international organizations or treaties, what protections are there left for domestic workers in the US?
Vote. Vote, vote, vote. The rest of the world begs you. Vote. This is, can I say that it's crisis proportions? And have a look at the AFL-CIO's complaint to the ILO, right? They know the ILO hasn't ratified most of the relevant conventions. But it's such an important document framing the extent to which workers across so many sectors, right, including the agricultural sector, including university professors, right, and state employees more generally. It's a really robust document which references but does not really spell out domestic work, I must say, but references the legislative exclusions. And it puts the case very clearly that this is active, actively putting people, government actively putting people in harm's way. It's a really serious document. It's a strong indictment, and its very existence is important. We'll see what the Freedom of Association Committee does with this text, with this complaint. But we know, right? So much of what they say about the NLRB, it's, well, it's known by the presidency, right? So vote, please vote.
Okay. We're going to move to back to history. And the question is, given the history of racial hierarchy in domestic workers' employment relationships, can changes in the law lead to equality and dignity for domestic workers, or is something else needed beyond legal reform?
A great question. I was anticipating this question, and it's at the core of the book. This is why I frame it through social movements. Law is important. I think it becomes too easy to say law is not enough. I think we need to sit long and hard with the ways in which law, and I'm using law broadly, pluralist law, shapes the world as we know it. It has a structuring factor. It enables actors to move through the world with a sense of the legitimacy of what they're doing. And so a challenge to that through law is critical. But that challenge operates at a number of levels. Yes, it operates in terms of the labor inspection and the mechanisms like the CCMA and the ability of actors to go there. But that set of frameworks will only work if it changes mentalities, right? Changes a sense of what is legitimate, changes a sense of what is possible. And so that demands so much more. It demands social movements to sustain and to propel and to transcend, right? So I encourage both taking the law very seriously, but also understanding it broadly and understanding how one moves through and beyond it for deeper and enduring social change, right? And domestic workers have understood that, and they've done that on many levels. So they've used the ILO to get the standards, but they've worked across governance levels and with society to convey a very different understanding of the value of their work and consequently their own value as the people who do this work.
Great. So we're going to go across to the other side of the world. And the question is that many scholars characterize Hong Kong as an exemplary place to work for migrant domestic workers, especially compared to many Gulf countries. Yet Hong Kong still hasn't repealed its live-in requirement for MDWs. What do you think about this characterization?
So I don't think there are many countries in the world who can claim to be doing swimmingly on domestic work. Let's just be clear. And I felt it was most appropriate to speak about my own, but there are very significant challenges. In the book, I focus on Hong Kong when I discuss a series of important cases, the Banao decisions, in which a domestic worker tried to contest her status and claim permanent residency, right? And this court case went through multiple levels of decision making, including at mainland China, and she lost. Right? The convention. This was sort of around the convention, but the convention was in place. But the convention 189 was not actually referenced in the case, and it was subtext. But one sees through that that the very serious challenges faced by domestic workers, and of course, one sees through it as well some of the limits of the convention. The convention doesn't challenge these characterizations. So I think when I speak about a learning community around decent work for domestic workers, I'm really referencing the fact that there is so much that needs to be done, right? And the convention provides an important reference. The recommendation supplements much of that. But how you actually make conditions for domestic workers decent is huge and will require much comparative insight, sharing, of course, commitment, and each country has a lot to learn. There are important processes, including through the Committee of Experts, which comments on conformity with Convention 189 and is able through that to offer guidance as well to states. But there's no El Dorado for domestic workers at this point, but there's a lot of innovation and creativity that is needed and that is in place and that we can learn from.
Thank you. And Adele, that's an excellent kind of segue into the next question, which asks if the Convention 189 had any influence on workers in countries that have not ratified 189, and particularly the Gulf countries, which may still practice the kafala system.
Yeah. Yes, great question. And the answer is yes. So the ratification is extraordinarily important, and it helps to have clear supervision, and it signals a commitment. But many states that have not ratified have nonetheless inspired their legislation or their innovation around the conditions or articles and paragraphs in the convention and the recommendation, which of course can't be ratified, but is meant to inspire. I gave you the example of Canada, which has not yet ratified, but is considering it in its change on live-in. In some of the Gulf states, one of the things we're seeing more of are provisions that deal with payment mechanisms that are standardized in ways that make it possible for third parties to verify that a payment has in fact actually been met. And, it's not complicated. It's sort of electronically done, rather than, leaving things to a more informal method of payment. And that has had some impact. There have been a range of other measures as well, attempts, for example, in Lebanon, which I'd mentioned, to reform laws on domestic work. And the ILO has been quite active in a number of countries. Some countries, through other UN organizations as well, have been putting in place reforms to streamline migration features and the like on domestic work. So there's change. It's slow. It's deeply imperfect, right? And in a moment like this, I think it's fair to say as well that attentions turn elsewhere, and so the urgency is just as clear. And I'd say finally that what's probably changed the most, even for countries that have not ratified, is that they know. Right? They know that, 10 years ago, 15 years ago, folks weren't really thinking about domestic workers as a subject of regulation. And really, there were, of course, the countries that frankly inspired the convention who were far ahead, but there wasn't this generalized sense of the possible. Mm-hmm. Now, hard pressed to have that same discourse, right? It's yes, domestic workers are workers. Yes, labor law applies. Yes, we need to think about how to do this. And so folks may be stuck on how do we do the inspection? How do we do the wage fixing in a manner that actually values the work that's being done? These are hard questions. Some countries have turned their minds to them. Many have not. But they're on the table, and they're on the table across the board, including some of the states with notorious track records. But a lot more is needed.
Adele, we're going to close with a final question that we can sneak in here that brings it back home, at least to the United States and to the state of New York. And so the question is whether there's a future of domestic worker created co-ops, as we've seen in New York City. And I would just broaden that to the accomplishments of the Domestic Workers Alliance, and without the legal, the recognition at the national level, what they have been able to accomplish.
Yeah, it's a wonderful place to end, because of course this is absolutely crucial, right? And the ability to think beyond models that have been received in traditional industrial relations, and to actually think about the kinds of organization that enable domestic workers to be to have autonomy. Right, to have some control, to set their conditions, to work in community, right, to challenge isolation, right. These are options that cooperative models may enable that other forms of representation and organization of the work may not enable, right. And so this is a moment for creativity, for regulatory experimentation, the thinking around co-ops. Frankly, there's some fabulous folks in the ILO who know the domestic worker dossier extremely well, and are at the center of the cooperatives units, the Melisim in particular. And there's movement, including, by the way, in South Africa, on thinking through the cooperative model for domestic work. So it's a great place to end, because it's encouraging and it centers domestic workers taking in hand and showing the way that they want to understand their work, carry out their work, and project that work. And I find that kind of mobilizing extraordinarily inspiring.
Adelle Blackett, thank you so much for this extraordinary presentation. We've got people that have stayed the full time that sometimes people drop off, and we've seen so many people stick around. I do want to say that this video will be available shortly, I believe, on YouTube, and we'll be sending around a link. We'll make that available and to all the participants for sure, and we'll make that publicly available. And I do want to thank you so much in a time when it's so difficult, and when all of us would love to have had you right here to ask you more questions and have you around for a couple of days. We have just thoroughly enjoyed having you here, and I've got all sorts of Q&As coming in saying, great talk, thank you, fantastic talk, etc. So we all really appreciate it.
Thank you. It's been such an honor.